Hello, everybody. Welcome back. Thank you for being here. I feel like I'm a little tall sitting. I don't know. How's that feel? How's that look? Does that look okay? Doesn't matter. Thank you for being here. Glad you are all here. Good to see so many of you already in the chat. I want to let you guys know a couple things. Number one, if you want to get my attention in the chat, just stick GF in there. That is what I use to kind of filter through all of the chats that happen with you guys. Sometimes we get into the hundreds and hundreds of chat messages. I can't go through them all. So just stick in GF and that will help me to find your chats. Today we are, let me see if my button's working. My button is working. Good. Okay. Today we are looking into the case of the murder of the man on the left, the right there, Eric Richins, 39-year-old Summit County, Utah man who was murdered on March 4th, 2022. And it is alleged by the prosecution that it was done by his loving wife, Corey, who's also seen in that picture. Here is a picture of Corey Richins in court. Another picture of the entire Richins family. Of course, this has been quite, that picture just kind of reminds me of there's just a little too much perfection there. Just a little too much perfection. But anyway, what's been going on, guys, is some craziness in court. Some craziness in court. And this is one of these cases that just goes nuts and has gone nuts from the very beginning, because we have got a woman who is accused of murdering her husband by poisoning him with a crazy amount of fentanyl. And then, in order to help her children cope, apparently decides to write a book titled "Are You With Me?" about their children's father in heaven being with, not father in heaven, their father, you know what I mean, their passed away father. And so the case is just absolutely crazy, but a couple of things have happened over the last couple of days, starting on the 14th and then moving into the 17th, that we want to cover here. We've covered this case not all that much, but I love it when there's crazy stuff happening. So I'm going to bring you over to a document that was filed on the 17th in Summit County, Utah, which is a motion. We're going to start with the motion to disqualify the prosecution. This motion was filed by Corey Richins' defense team, her lawyer, Sky Lazaro, and then we're going to look at a motion that was filed the same day. That was a motion by the same defense counsel to withdraw as counsel and appoint new counsel. Now, there are plenty of people out there with suspicions as to why this is the case. I don't know why this is the case, but we're going to go through the motion nonetheless. Let us start, though, with the motion to disqualify the prosecution, because for me, this one is the one that is, I guess, a little beyond the pale for me. All right, here we go. Let's see. Let me just set myself up here so I can see things. Okay. Phoenix Rising knows how to do it. She knows how to do it, or he, I don't know. But either way, thank you very much, Phoenix Rising. All right. Defendant Corey Darden Richins, by and through Sky Lazaro of Ray Quinney and Nebaker PC, and attorneys of record, hereby moves the court to disqualify the Summit County District Attorney's Office from the above captioned case, which is State of Utah v. Corey Richins. Requested relief and grounds. The defendant respectfully moves this court to disqualify the prosecution from this case, and specifically Chief Prosecutor Brad Bloodworth, due to his involvement in severe violations that compromise the integrity of adversarial fairness. Adversarial fairness, by the way, is an important doctrine within the law, and this is something that all lawyers are trained not to cross lines, right? They're ethical lines. So there's an allegation that Mr. Bloodworth has crossed that line. Mr. Bloodworth and the prosecution's continued presence in this case poses a significant risk of further exacerbating these issues. Phoenix Rising, very much a she, her. I assumed. Thank you very much. All right. Relevant background. Guys, this is a big deal if the allegations are true. On December 11th, 2023, defense counsel emailed Summit County Attorney's Office the following, notifying them that she discovered Corey's jail phone calls to defense counsel had been produced in discovery. So, let's read it. Summit County team, I discovered this morning while reviewing discovery on Box, which would probably be an electronic way of delivering discovery, that the jail has been listening to and recording Corey's jail phone calls to Ramsey, and they're produced on Box. Did you know that this has been happening? Ramsey is clearly an attorney of record in the criminal case and the DCFS case, so I am concerned. There are other civil cases going on at the same time, as you guys know. See emails regarding privileged confidential jail calls produced in discovery, hereto attached as Exhibit A. Paragraph 2. In the series of responses that followed, Summit County Attorney Brad Bloodworth, who is now lead counsel in this case, stated, Ramsey refuses to register for and use the HomeWave app that shields attorney-client calls. His calls are, therefore, recorded as any other call. Mr. Bloodworth goes on to state that the prosecution has been listening to at least a portion of the calls between Corey and defense counsel since May 2023, and the entire prosecution team has been in possession of the calls for the entire period between May 2023 and December 2023. He further took the position that because defense counsel had not downloaded the HomeWave app, quote, it seems that Ramsey consented to the state maintaining the recordings. Paragraph 3, defense counsel responded, whether or not Ramsey uses the HomeWave app, attorney-client privileged calls are in the possession of the prosecution team, which is the concern. And that is true. And by the way, this kind of tactic, we don't know if they listened to the calls. What we know is that they had them in their possession and that they listened to at least a portion of the calls. It could very well be that the prosecution is going, they're not on the phone. They're pushing play and it says who is on the call and they go, oh, can't listen to that. That is possible. Knowing just that, that is a privileged call. But the legal doctrine is that attorney-client conversations are privileged. So defense counsel is like, I don't care if you want us to use an app or not, our communication is privileged, which I think is a fair position to take. All right. Paragraph 4. Defense counsel has never consented to the prosecution listening to recorded calls. Corey has never waived her privilege in those conversations. Both Corey and defense counsel believed that calls between them were privileged and that the state was not listening and did not have possession of them. It is universally understood. Actually, before I go on, by the way, just can you imagine if you're in any office? In this case, it's a legal office. You're in the prosecutor's office, right? And in the possession of the prosecutor's office is a series of recorded phone calls between the person you're prosecuting and their lawyer. The lawyers might say, you know what, that is a bridge too far. I'm not crossing that line. I'm not going to listen to those. But are you telling me that there isn't somebody in that office that would listen to those calls? I'm going to what is the word that I'm looking for here? I'm just going to tell you what I would do as a young man. Like I was an IT guy in my early 20s. If I had access to something, which I had access to everything, I was the IT guy, right? I was nosy. I was snoopy. There were things that I should not have looked at, heard, watched, or known. There are just so many of those things, right? So you're telling me that in an office full of lawyers who, let's give them the benefit of the doubt, are going, nope, I'm not crossing that ethical boundary. I guarantee you at least the IT guy has heard them all. And that's not okay. I shouldn't give you that guarantee. It is my deep suspicion, suspicion that at least the IT guy, maybe the secretaries, maybe a lot of people in that office have heard those calls. And that's not good. All right. Paragraph 6. It is universally understood and accepted by attorneys across nearly every jurisdiction in the country that irrespective, I don't know that that's a word, but okay, of whether defense counsel downloads an app or listens to a pre-recorded notification that a call would be recorded, that jail calls, or all calls for that matter, between defense counsel and their clients are privileged and confidential. Summit County Attorney Margaret Olson immediately removed the calls from the discovery available to the prosecutors and placed them in quarantine box. It should be noted that Ms. Olson has been diligent in her efforts to remove other electronic communication that was missed by the privilege review team and notified defense counsel of the same. Well, that's great. So Attorney Olson has integrity. That's terrific. Okay. On March 26, 2024, defense counsel visited Corey in the Summit County Jail. She notified Sergeant Thomas that she would need a paper pass as the defendant had notes relevant to the defense of her case to give to counsel. Sergeant Thomas is the same Summit County Sheriff's officer that conducted multiple searches of the defendant and her cell and improperly seized the WTD letter, read it, and turned it over to the Summit County Attorney's office. Somebody remind me, what is the WTD letter? I'm just going to look that up real quick. The walk the dog letter. I gotcha. Okay, the walk the dog letter. I remember now. All right. Getting back so I can read. All right. At the end of the visit, defense counsel asked Sergeant Thomas to facilitate the paper pass. Defense counsel notified Sergeant Thomas that the notebook contained privileged information and the pages were clearly marked attorney-client Sky Lazaro at the top of every page. She further notified Sergeant Thomas that he could not read the pages and could not take the notebook, but that he should simply flip through to ensure nothing was stuck between the pages. An argument ensued between defense counsel and Sergeant Thomas as to whether Corey could give her counsel notes. Sergeant Thomas referenced that he was made aware of a prior problem, referencing the envelope and fictional manuscript that was ruled to be privileged attorney-client communication and work product. Sergeant Thomas spent several minutes looking at every page of the notebook, during which defense counsel repeatedly told him he could not read the pages and was violating her client's constitutional rights. Again, each page was clearly marked attorney-client Sky Lazaro at the top. Now, guys, why do we care about this? I mean, I feel like the evidence is pretty overwhelming that Corey Richins probably killed her husband, right? So because this is the case, we definitely want her to be convicted, right? Or plead guilty. Either way, we want a conviction. We want her to serve the time necessary or whatever the penalty is. We want her to serve that penalty. Now, so why do we care about her constitutional rights? Well, for a couple reasons. Number one, if Constitutional rights are protected for one, they are protected for all. And if they are not protected for one, they are not protected for all. So that's number one. Number two, if they go through the process of doing the whole trial, the whole prosecution, and it ends in a conviction, the likelihood of her conviction being overturned on a technicality is high when those technicalities are often and well documented. So we want a fair game. I'm not defending Corey Richins, but we want a fair game in the interest of justice. That's what we want. And I know that I'm like preaching to the choir here, but that's why it's important to me. All right. Defense counsel suggested they speak to Judge Mrazek about whether Corey could give her counsel handwritten notes. Sergeant Thomas, unsure what to do, left the attorney booth and returned with his captain and Mr. Bloodworth. Sergeant Thomas, his captain, and Mr. Bloodworth asked to speak to defense counsel outside the attorney booth. Counsel had her back to the wall in the corner while the three stood around her and intensely interrogated her about the contents of the notebook. Counsel repeatedly told them it was privileged. You know, Attorney Bloodworth should know this. Okay, counsel repeatedly told them it was privileged, that they could not take it and they could not read it. Counsel repeatedly stated to Sergeant Thomas, his captain, and Mr. Bloodworth that they're violating her client's constitutional rights. Let me pause here for a second, okay? Because trying to be sympathetic to the jailer, Sergeant Thomas and his captain, okay? They're told all sorts of stuff by all sorts of people. They're lied to all the time. Therefore, it is appropriate for them to be suspicious. Totally get that, right? On the other hand, if I can play devil's advocate here. And we're going to get to a conversation about devil's advocate. Remind me before we end. But if I can play devil's advocate here for a second. In my experience, jailers, people who are working in county jails all across the Fruited Plains, are undertrained, undereducated, and underpaid. They're underpaid. They're undertrained. This should be something that it's like, okay, there is attorney-client privilege. We all know there's attorney-client privilege. Everybody should know, is it legal and is it appropriate for them to pass pages, as the attorney said? That they're under everything in the county level, the jail level, criminal justice. Oh, I don't even know if we would call it that, but Department of Corrections or whatever. So, all right. Let's see. Sergeant Thomas, his captain, and Mr. Bloodworth took the position that unless it was a legal document, Corey could not give the notebook to her counsel. Counsel continued to explain that the information in the notebook are notes material to her defense to assist counsel. Mr. Bloodworth questioned Sergeant Thomas as to the contents of the notebook, whether it appeared to be legal material, and whether it appeared to be related to the case. Mr. Bloodworth asked Sergeant Thomas several times if he was sure to look at every page and whether he adequately inspected it to ensure it was legal material. The captain went on to suggest that they all go through it again. Despite the intimidation and interrogation, defense counsel refused to allow the notebook to be inspected or taken from her client. Keep in mind, by the way, guys, that, again, we're going to be devil's advocate here. This document, this motion to disqualify the prosecution, is written in such a way that they are trying very hard to convince a judge to disqualify the prosecution. There is not going to be anything in here that is exculpatory at all, right? I doubt she felt intimidated, cornered. She is a strong, powerful woman, highly educated, and I doubt that she actually felt in a corner, intimidated by these three, I am guessing, men. But if the fact is that she was in a corner and that she felt like these were intimidation tactics, then that is what she is going to tell the judge. Whether the judge believes it or not remains to be seen. Okay. Following this tense confrontation and interrogation of defense counsel, Mr. Bloodworth gave the sergeant permission to allow defense counsel to take possession of the notebook. By the way, how far away is the district attorney's office from the jail? Like, even the close ones. I'm wondering if it's in the same place. I don't know. Okay. Following the tense confrontation and interrogation of defense counsel, Mr. Bloodworth gave the sergeant permission to allow defense counsel to take possession of the notebook. Defense counsel subsequently requested all communication between the Summit County Attorney's Office and the Summit County Sheriff's Office as it related to the case, defense counsel and defendant, and to include a call log. Mr. Bloodworth represented to counsel that there was no communication. A call log was never produced. Well, then how? Okay, Sergeant Thomas's statements and Mr. Bloodworth's appearance at the jail with regard to the notebook issue would indicate that there was at least one call from the sheriff's office to the prosecutor's office. I agree. Okay. Argument. The ultimate decision to grant or deny a motion to disqualify counsel is within the trial court's discretion, all the case law. Disqualification of a prosecutor is a remedy within the court's authority to maintain fairness of the proceedings. This measure is not only appropriate but necessary when the prosecution's actions have compromised a defendant's right to a fair trial. In this case, the prosecution, and specifically Mr. Bloodworth's intrusion, has irreparably damaged the adversarial fairness that the Sixth Amendment and due process seek to uphold. Disqualifying the prosecution is essential to restore the adversarial fairness of the judicial process. If Corey Richins were convicted in her husband's murder and they were to appeal on Sixth Amendment grounds, from what I've read, that is a pretty darn good appeal. I would really hate for a conviction by a jury to be overturned on the Sixth Amendment grounds. Okay. Let's see. Argument number one. The prosecutor violated the defendant's Sixth Amendment right to effective assistance of counsel and should be disqualified. The Sixth Amendment right to counsel serves as a critical safeguard to ensure that defendants receive fair trials. And then blah, blah, blah. Okay, this right extends beyond merely having legal representation. It encompasses the right to effective assistance of counsel, which this is all... Sure, there's tons of federal case law on this, and in every state in the union, there is case law. Specifically, it ensures that a defendant's right to be assisted by an attorney who plays the role necessary to ensure that the trial is fair. The U.S. Supreme Court has long recognized that an essential part of this right is the ability to communicate freely and confidentially with one's attorney. Any intrusion on this confidential attorney-client relationship constitutes a direct violation of the defendant's Sixth Amendment rights. In this framework, a trial is considered fair if the adversarial process operates in a way that supports confidence in the outcome. Conversely, a trial is deemed unfair if a failure in the adversarial process leads to an unreliable outcome. Blah, 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 blah. We're not going to go into all of the case law. For example, I don't know if we need to really get into all this case law. Let's go ahead and skip down. We are going to go to the next. We get it. Okay, number 2. The court should exercise its discretion to disqualify the prosecution. I wonder what would happen if the prosecution were disqualified. If the prosecution were disqualified, does that mean they have to go to a different county, a different prosecutor's office, or would they use the same prosecutors in the, or different prosecutors in the same office? Mooney asks, has the state responded to this yet? Mooney, no. This was filed on the 17th, which was Friday. So it'll probably be a couple weeks before there is a response to this. And there was a hearing scheduled, but because the defense had motions to what was it? It's not quash. They had several items of evidence. Okay, let me pause here for a second. We aren't even to the preliminary hearing stage on this yet. Okay? Everybody's arguing about everything leading up to the preliminary hearing. The preliminary hearing in the state of Utah is very much the same as it is here in the Commonwealth of PA. In the preliminary hearing, the prosecution will deliver its case with the defense present. The defense can question witnesses and so forth, and then a judge decides if there's enough probable cause to hold it over for trial. Okay, we're not even there yet, and they're arguing over exhibits, and so the defense made a motion to exclude some exhibits from the preliminary hearing, and so that has pushed off even the next hearing, right? So there's a lot going on here. This case is going to drag and drag and drag. I am sure of it. So yeah, long-winded answer, Mooney, but yeah, the state has not responded yet. All right. The court should exercise its discretion to disqualify the prosecution. The court has discretion and authority to grant a disqualification. This case has been rife with violations since its outset. Despite the court's denial of defendant's motion to dismiss, there remains an ongoing problem in this case. For instance, Mr. Bloodworth listened to at least a portion of Corey's calls with defense counsel from May 2023 to December 2023. Worse, Mr. Bloodworth justified this behavior, stating it was defense counsel's fault for failing to download an app. This was his entire justification for violating attorney-client confidentiality and the Sixth Amendment protection afforded to defendants. These calls were placed into evidence admissible to the entire prosecution team. Additionally, Mr. Bloodworth appears to have decided that Sergeant Thomas can conduct privilege review of any written correspondence. This is a really good argument that Corey attempts to give her defense team. Furthermore, Corey has filed subsequently herewith a motion seeking suppression of the Walk the Dog letter due to the circumstances surrounding its discovery. Moreover, the court has previously ruled that the envelope found in Corey's jail cell labeled attorney-client privilege containing the letter was privileged. However, video evidence of the cell search reveals that officers meticulously examined each and every page of the envelope and read its contents. That is messed up. Notably, the same sergeant involved in this search had ongoing communications with Mr. Bloodworth. It is clear from Sergeant Thomas's statements to defense counsel that he is privy to information about the case, indicating he and Mr. Bloodworth have discussed the case. Wow. All right. Sergeant Thomas now has information related to the defense strategy from the notebook that he reviewed. It appears the two are effectively working in concert to violate the defendant's Sixth Amendment rights. While the court should, at minimum, disqualify Mr. Bloodworth from this case, every attorney in the Summit County District Attorney's Office where Mr. Bloodworth works is assigned to this case and has had access to the cloud-based box folder containing all of the evidence, discovery, and other sensitive information in this case. Let's just for a second, I'm going to mark my place there, and let's just for a moment, I just want to do a search. Yeah. So Summit County is still a small county. 43,000 people at the census. So let me hide that. 43,000 people at the census. Okay. Now the county that I live in right now is population about 35,000. There are currently a grand total of 2 prosecutors. There were 3 until last year when one of the prosecutors was elected a circuit or Court of Common Pleas judge. So I'm guessing, based on what, and you guys know that this is, my hometown is in Summit County, where I spent my childhood years, where my grandparents were raised. That town is in Summit County, Utah. Both of the towns where my grandparents were raised are in Summit County, Utah. I know it really well. Not as well as if I lived there my whole life, but I know it really well. Okay. There's basically one place in the entire county that people would know about, and that is Park City. Everywhere else in the county are just tiny little dots on a map. Camas is probably the next biggest. Camas is still a tiny place. Okay, so yeah, it's not like this is a prosecutor's office that has dozens and dozens of prosecutors. This office might have 4 or 5 or less prosecutors in the entire office. Okay. Given the office's small size and the close working quarters of each of the attorneys, there is a high likelihood that each attorney in the office has had meaningful access to the evidence and sensitive information, and even been privy to privileged communications. You know what just occurred to me too? Park City, when I was a kid, sorry to go on these tangents, but when I was a kid, Park City was still kind of a coal mining town. There were ski lifts, very few of them. They had just built a very nice golf course out there called Jeremy Ranch. It was still a pretty small town. Now, I know that it's grown more since then, but I also know that so much of Park City is just like every other alpine community, like Lake Tahoe and so forth, right? They are very transient. So if there are 43,000 people in the county that they're counting, I would imagine that it gets bigger than that in the wintertime, and I would imagine that it is much, much smaller than that in the off season. I don't know why that's important for me to bring up, but I would imagine that that is the case. Okay. Although typically only one attorney from an office should be conflicted out of a case when issues arise, this situation is unique. All of the prosecution's attorneys had access to the same discovery materials, and even though access to the attorney-client communications was eventually removed, there was a period during which the entire office had access. With only a handful of attorneys in the office, the risk of widespread contamination is significant. Corey pleads with this court to be vigilant in protecting the rights of the accused and ensuring that all parties adhere to the highest ethical standards. Allowing the prosecution to continue in this case after violating the defendant's right to effective assistance of counsel and intruding on confidential and protected information would undermine public confidence in the criminal justice system and erode the foundational principles of fairness and due process. In conclusion, Your Honor, for the reasons stated above, the defendant respectfully requests that the court exercise its discretion to disqualify the prosecution, and particularly Mr. Bloodworth in this case. Such action is necessary to rectify the violation of the defendant's Sixth Amendment right to effective assistance of counsel and to preserve the integrity of the judicial process. The adversarial fairness and due process that form the cornerstone of our legal system must be safeguarded, and the disqualification of the prosecution is an essential step in achieving this end. Okay, I think that Ms. Lazaro has made a pretty compelling argument. I think she's done a very good job here, and I think she is probably a fine attorney, one that Corey Richins could probably use right now. But there's a twist. Dun, dun, dun. There's a twist. Before we get to the twist, though, hey guys, let me remind you that anytime you want to reach out to me, the best place to do that is at my website, gavinfish.com. There is a contact button right here that will take you to a form that you can fill out, and those all come to me. Now, I get like hundreds of them, sometimes hundreds a day, not many hundreds a day, like 100 in a day. But definitely hundreds throughout the week. So I don't respond to all of them, but I deeply appreciate them. If there's anything that you want me to see, any documents that you want to upload, that is where you can do it. Just click on contact and that will take you to this form. You can be completely anonymous, by the way. Okay? Completely anonymous, which I'm happy about. Number 2, if you click on this little button right here, that will take you to the fish tank, where we are now over 900 members. We're closing in on 1,000 members of the fish tank, which is just a bunch of us, members of the community of the Gavin Fish YouTube channel, talking about cases. You will notice this post that I put up a little while ago. Yes, indeed, Jennifer Coffindaffer. Yeah, tomorrow I'm going to be talking with retired special agent Jennifer Coffindaffer about the Karen Read case right here on this very channel. There are people that are upset about that. But I say I like to talk to all sides. And so I will be talking to Ms. Coffindaffer, who I've talked with her in regards to the Ellen Greenberg case. I find her to be a delightful person, one that I give the benefit of the doubt to, somebody who has the bona fides that I do not. Many of you probably disagree with me. And so this is your opportunity to tell me the kinds of things that I should be asking Jennifer Coffindaffer about the Karen Read case tomorrow. So please head on over to the fish tank, join, put your comments down below this post, and join me tomorrow at 7:30 p.m. for my conversation with Ms. Coffindaffer. Okay, let us get back. Where were we? Oh, yes, I was just saying that Ms. Lazaro is a fine attorney. Her argument here is compelling. She seems to be a fine attorney, one that Corey Richins definitely needs. But let's go to the next document. This is a motion to withdraw and appoint new counsel. Now, I have to say, I'm a little bit nervous about what this might mean. Okay. Ray Quinney and Nebaker PC is hereby providing notice to the court that it has a professional duty to withdraw from its current representation of the defendant, Corey Richins. The ethical mandate for withdrawal results from an irreconcilable and non-waivable situation. It first emerged from the civil cases in which the firm has been representing Ms. Richins, but is imputed to the firm as a whole and thus requires the firm to withdraw from its reputation of the defendant in this criminal proceeding. This matter emerged after the hearing held on Wednesday, May 15th, 2024. The court and opposing counsel in the civil matters are being notified today of the firm's withdrawal. To properly safeguard the defendant's constitutional rights, this court should immediately grant the firm's motion to withdraw and should immediately appoint new counsel to continue the vigorous defense of the criminal charges against Ms. Richins. Now listen, this is where I must confess something. There's probably tons of people with all sorts of opinions and gossip about what is the matter that emerged from the hearing on the 15th. But I, sadly, have not been paying close enough attention. So you guys tell me in the live chat, do you guys know what this is? Because what's really funny is that in the other ones, in the civil cases, it is quick to say in the same motion to withdraw. I've got another one. I should have brought that up. Let me bring that one up real quick. I've got another one that says, and by the way, there are no open or outstanding motions in front of the court. let me see what this one is. This one is, yeah. So here is this is Katie Richens v. Corey Richens. And in this one, they're like, yeah, we definitely have to remove ourselves here. No motion is pending. No hearing or trial has been set. So that is the case in the civil trials, but in this one, or in the civil cases, but in this one, there are motions pending and a trial, is coming. And so I am very, very curious what you guys think might have caused that issue. Cassie says, Gavin can't wait for tomorrow's live. Yeah, I think, Cassie, it's just going to be you and me that are looking forward to that. There are a lot of people that are angry that I am doing this, but yeah. Let's see. GF, I just don't understand all these crimes against spouses. I mean, it just seems like a divorce would be a better because you are not going to get away with it. That's funny. Yes. That is interesting where people's minds go, right? When they're trying to problem solve. My guess, this is so obvious, but my guess is it was all about money. I mean, we know that she thought that she was the beneficiary of his work life insurance and all that stuff. So I'm guessing with her deep, deep debt and her real estate venture that she was looking for a way to get money, and offing her husband, who she didn't particularly like, seemed like a good idea. Not a good idea, folks. Only stupid people do things like that. Like, you guys know my iron law. I say it all the time. It should be Gavin's razor. We should call this Gavin's razor. But, like, if you think you got what it takes to get away with a crime, you think you have what it takes to be a criminal mastermind, that is the only evidence you need to indicate that you do not have what it takes to get away with a major crime, to be a criminal mastermind, right? That is Gavin's iron law. I'm just glad that so many of them are stupid. I'm sad that I think that there probably are a lot of people that get away with stuff like this. I think there probably are. I mean, I've told you the story about my friend who is a judge out of my state, who she has told me on numerous occasions that when she drives anywhere, if she's driving like through the forest or driving through the plains or driving through the desert or driving through the whatever, she's always looking out along the side of the highway thinking, I wonder how many bodies are out there. People do get away with it. It's just the stupid ones that don't. Yes, I am in Pennsylvania. Let's see. Could it be that Corey implicated Skye in the Walk the Dog letter? Yeah, possibly. I don't know what was in that letter. You guys help me out if I'm talking outside of my face. I don't know what the contents of the Walk the Dog letter are. What is in the Walk the Dog letter. So I don't know, Mooney. You probably know better than I do. I think that Mooney should join my team of researchers. Mooney, if you want a volunteer non-paying job, reach out to us on the Fish Tank. I would love your research on this kind of stuff. Kelly, I'm missing something. Why are people upset about tomorrow's live? Oh, people are upset about tomorrow's live because many people found my channel when I had Sean McDonough on. Sean McDonough is a retired DEA supervisory agent, brilliant guy, tons of law enforcement experience, who believes that Karen Read is being shafted, being completely hung in a frame. And I think his argument is compelling. In fact, I've done a follow-up video about the dog bites. I think those are dog bites. Well, Jen Coffendaffer has a differing opinion. And I think a lot of people have come to the channel thinking that I'm on Sean's team, when the reality is I'm on nobody's team because I don't have enough information to be on a team. What I have noticed about the Karen Read case, though, is the personal investment that so many people have put into the case. And I will say this, and this is a tangent on another case that we're going to be talking about tomorrow. If she has been put in a frame, then I want her to be found not guilty. However, if the evidence is compelling and untainted, I guess I would say that, and convinces a jury that she is guilty, then she should be found guilty. That's just my opinion. All right, guys, it doesn't look like we have any other questions or comments, but thank you very much for let's see. Mooney, have you seen the Walk the Dog letter? Is that what you're saying there? Yes. I don't know. Anyway, guys, thanks for joining me tonight. I deeply appreciate it. Thank you. The channel has grown so much. In the last 4 weeks, we have over 10,000 new subscribers. And I'm so grateful to all of you. Very grateful for your support, whether it's watching, sharing, liking, subscribing, being a member of the Fish Tank, being a member of the channel, being a patron on Patreon. However you support me, I deeply, deeply appreciate it. And several of you have been supporting my mods too over on Buy Me a Coffee. I appreciate that too, because they are volunteers. They don't get paid for this. So if you go over to my website, let me show you this on the way out. There is a support page. If you scroll down to the bottom, there's a button, Buy Mods a Coffee. If you want to take care of Autumn and Jamie, that is the best way to do that. With that, ooh, hold on. One more. I'm on the fence with Karen Read. I just don't know. Well, you and I both, but you probably know more about the case than I do. So I have a worse excuse. Okay, with that, I will bid you adieu. Thank you all for being here, and I will see you hopefully tomorrow. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.